I think that all exercises of the veto are tested against whatever this court would ultimately determine is the proper test for evaluating the governor's partial veto authority, be it the one that we think is most workable, and that is Justice Hansen's test in his Henry concurrence, in which he asks whether the part that has been vetoed is a complete and workable law, or if for some reason the court does not prefer that alternative, then the test, which I think can fairly be implied from the majority opinion in Henry, which is that the exercise of this partial veto may not take out something that is essential and inseparable from what the legislature had passed and transform it into something new.
So you're asking us basically to either distinguish or overrule a considerable number of cases that have occurred since Henry, correct?
Well, I think in particular, Chief Justice Rogenstock, yes. Two cases, depending upon how the court chooses to choose this. In our view, the court should overrule both Henry and adopt Justice Hansen's concurring test for assessing Article 5, Section 10, or if it does not wish to overrule Henry, then Kletchka. There are some other cases that have come down along the way. Sunby, I think, among them. I don't think the court really grappled with any of these issues in those cases because it didn't have to. So you have, I think, Henry and then Kletchka, which was decided 40-some years later, and then the Thompson case, which was decided shortly after Kletchka, and which essentially followed the court's prior analysis of the issue, although it did draw a three-justice dissent.
Counsel, could you tell me a little bit more about your focus on Hansen's dissent in Kletchka as the appropriate test? In particular, I'm interested in why we would be concentrating on the material that was vetoed as a test when if there's a constitutional violation here, it's with respect to what's left, not what's vetoed, right?
That's right. It's with the process that creates what's left. But I believe that Justice Hansen's test, concurring in Henry, makes the most sense because it tracks the purpose of the amendment to Article 5, Section 10. That is, it responds to the gubernatorial concern about the combination of laws that could have been acted separately into one omnibus bill. And by saying that, to borrow Justice Bablich's phrase, we concurred in, or dissented rather, in Thompson, the governor's power to disassemble should be consonant with the legislature's power to assemble. And so if we are going to permit, and we do, the legislature to combine a variety of legislative initiatives in a budget bill, then the governor should be able to veto each distinct legislative initiative. If that's so, then the best way to determine whether the governor has exceeded his or her veto authority is to look what has been vetoed and see if that itself could have been passed as a separate piece of legislation. That is,
okay. Yeah. So let me stop you there. So I think I get that. So my question is this: the constitutional challenge here is that this construction of the partial veto allows the governor to actually create a new law with the veto, correct?
Yes.
And that violates the vesting clause and a few other clauses of Article 4. So would it be possible, is it conceivable, that a veto could meet the Hansen dissent test, but still have the remaining language not be operably the same as it was before the veto, right? That is to say, if I understand your position correctly, what you're after is that remaining language should operate the same as it did before the veto as after the veto, right?
Well, I think that would be true if the court adopted the test that can be applied from the majority opinion in Henry, right? This would be a somewhat broader test that would ask whether or not the governor has somehow transformed the legislation that has been presented to him. Sometimes that's easy. An appropriation for school buses is not an appropriation for electrical vehicle charging stations. Sometimes it may be less clear. One of the concerns that the court has had in the past is whether or not such a broader test would be workable. I think it would be. I don't believe that it would be as difficult as it sometimes has been supposed to be. And it's one that this court could adopt if it believes that it more consistently adheres to the purpose behind the amendments to our Article 5, Section 10 in the constitutional language. The test that focuses on whether or not what has been excised is a complete and workable law, however, has the advantage of being somewhat more objective and as I said before, tracks the purpose behind the 1930 amendments to Article 5, Section 10.
Right, but could a veto satisfy the Hansen test, but still change the meaning of the remaining language from what it was before the veto?
It's possible. I think it's unlikely because one would have to be excising something which is itself a complete and workable law. But this is an area in which governors and staff and lobbyists have proven quite creative, and there may be a hypothetical in which that could happen.
Okay, so perhaps that's the test to use if this is an appropriate approach to the partial veto. Given that test, is the objective to make sure that the remaining language is something that the legislature had proposed and passed on?
Yes, and I think both tests that we proposed are a way to do that, and yet respect this court's institutional concerns about having a sort of a judicially applicable and discernible standard by which to assess these things going forward.
Okay,
so isn't it true that you're really asking this court to make a new policy decision, given that the legislature has had the opportunity over 85 years to make the change that you were advocating for? There's been 2 constitutional amendments passed, neither of which defined part in the way you are now asking the court to do. And so you're asking us to make that choice as opposed to the legislature through the process of constitutional amendment, which is how it's happened over the course of history.
Yeah, and I understand, Justice Bartlett, that this is something that the court is going to be concerned about. How do you treat these past amendments that didn't get out of the legislature and the 2 that were passed by the public? In my view, I think that it's important, first of all, to note that it is the duty of the court to say what the law is. And if, in fact, after reviewing the arguments, the court is convinced that Article 5, Section 10 does not, in fact, support this type of recreation veto, then it seems to me that there's a fairly powerful imperative that the law should be applied as it is written. And it should not be incumbent upon either the legislature or the people to fix that, that we should apply the law as the law really is.
Well, I understand that, counsel. We've said what it is, though, through the course of history, and we also have two constitutional amendments that are essentially rendered superfluous by your reading now. And so what you're asking this court to do is not only impose a new reading that's never been there over history, but also to really go above and beyond the will of the people when they've had the opportunity to have spoken and haven't.
Yeah. I would respectfully disagree that we would be asking you to go beyond the will of the people for the following reasons. I think that when we're talking about what we can infer from the passage of these constitutional amendments, the important starting point is that the people can pass upon only what they've been asked to pass upon. You know, we typically, when we have a canon of construction that will against having surpluses or superfluous language, we're usually talking about a particular drafter, and it's based upon the presumption that a drafter doesn't add in unnecessary language. So that simply doesn't apply here, because the people passed Article 5, Section 10 in 1930, when they're asked in 1990 or 2008 whether or not a particular abuse or claimed abuse based upon the court's interpretation of these provisions should be permitted or not. That is all the people that have been asked to pass upon. It's not possible, it's implausible to think that anyone who was voting on these amendments in 1990 and 2008 had in their mind that, well, I don't want the governor to strike out individual letters or to combine sentences, but it's okay if words are stricken within the confines of a particular sentence. I just don't think that's a particularly strong inference from what actually happens in this process. Sometimes an amendment can tell you something about what the people think. And I think Ward is an example of that, where it's reasonable to infer that if the people say that a judge cannot hold a public office after he has resigned from his term, then the judge also may not hold public office before he's resigned from his judicial position. But that inference doesn't follow here, because all we know is the people were asked to respond to a particular thing that the legislature put before them, a particular exercise of the veto as it has been interpreted by the court. And when the people were asked to do that, they said that they don't want governors rewriting laws in this way. If anything, it infers that there is not an acceptance of the court's interpretation over the years, and certainly not one that anyone has relied upon.
Counsel, are you asking us to overrule the Thompson case?
Yeah, I think you would overrule. I think the Thompson case would be overruled as well if one overruled Kletchka and Henry in the way that we've asked you to do it.
And what other cases dealing with partial veto are you asking us to overrule?
We've asked you to overrule Kletchka.
Yes.
And we have asked you to overrule Henry, although if you choose not to overrule Henry, it is still our position that these particular vetoes would be unconstitutional based upon an overruling of Kletchka.
Give me a laundry list of the cases you want us to overrule. Do you want us to overrule Sunby and Martin?
I don't think Sunby, other than dicta, I don't think either of those cases presented the issues that are presented here. I think all of them, and in fact,
Counsel, if we take the position as a court that in our opinions there is no dicta, in fact, in Sunby and in Martin and the Cub case and certainly Thompson, all of these reiterate the very things as law that you are now challenging. It seems to me that we would have to overrule not only Henry, as you suggest, and Kletchka, as you suggest, and Thompson, as you now indicate, but all of those cases.
Yeah, we'd certainly have to disapprove of the language. I agree with that.
Yes. And so what is a case other than the language? Do you think it's just the holding?
Well, it could be. I mean, it depends. I mean, I think, for example, this case doesn't. What we've asked here doesn't really address whether or not the governor can, write down a number in a budget bill. We absolutely are asking this court to change the way in which it has interpreted Article 5, Section 10 in the cases over the years where these particular issues have come up.
So the answer is yes. That whole line of cases should be overruled.
Yes, I think so.
Counsel, can we talk just a little bit about some of the original public meaning evidence here? A couple of things that I think are counterweights to some of the evidence that you put forward that I'd at least like you to address maybe a little more fully than I felt like you did in your briefs. So the 1925 amendment that was proffered, that was brought up by the Attorney General, does that weigh at all into our understanding of the fact that there was a difference between item and veto, or item and part? The one that was proposed, that did not obviously pass, but it at least reflects some understanding of the use of language at the time. And the other two pieces I guess I'd like you to address as well is that, not long after this amendment gets passed, you have the governor who seems to think it's not an item veto and deletes, language that wouldn't necessarily be consistent with the test you have. And you have the Supreme Court unanimously, again, not long after this, ruling the other way from what you're proposing now. And at the very least, those are other pieces of evidence that would counterweight to some of the pieces that you put forward and the articles and public debates that call it an item veto in some circumstances. So how do you weigh that competing evidence, and how would you address those three data points?
Well, the 1925 amendment, I think, is difficult to make too much out of because it talks about an item, it talks about part of an item. That seems to me inconsistent with the argument that is being made by the respondents here that a part is somehow a broader concept than an item. I think if we look at what the history is, it does not support an inference that there was a public meaning that part was somehow distinct from item. Right? They seem to have used the term interchangeably, both in the legislative process and in the public debate that followed. Contemporaneous Supreme Court decision did draw a distinction between items as appropriation items in a budget, and part as substantive, non-appropriation items that would be included in a budget bill. But that supports the respondents' position here. And so I think that the weight of the constitutional evidence is that this distinction was not drawn, or at the time of the enactment, or that the sort of the definition of part and item would have supported either interpretation.
So Counsel, just on the 1925 amendment, though, it's use items or parts of items, which at least seems to suggest that the word part in the context of a veto might mean something less than a full item.
It's possible. I mean, one could read it that way. But I think when we're attempting to ascertain the original public meaning of something, I think we have to look at where the weight of the evidence lies. And the weight of the evidence seems to be that this distinction between item and part was not drawn by the legislature or by the public in passing upon in debating these constitutional amendments. And certainly the dictionary definition that existed at the time would not compel the definitions that the respondents argue for today. And even Henry itself, although it did talk about the difference between item and part, left open the possibility that if something was a essential, or I believe it used the term inseparable, part of a piece of legislation, then it could not be vetoed by the governor. And it wasn't really until 1978 that we were faced with the type of expansive use of this partial veto, which has sort of created the controversy which has led us here today. For a long time, I think people might have reasonably assumed that if something transformed the law because it struck something which was essential or inseparable, that it would have been an improper use of the veto. And I think that certainly probably influenced the way and people viewed this veto and the level of controversy surrounding it.
Counsel, could you please go through, I understand your overriding test, but could you go through the 4 pieces of legislation and the 4 vetoes here and the provisions and how your test applies specifically to those 4 different veto?
Certainly. So with respect to the appropriation for school buses, what has been excised there, which was essentially everything. It was an appropriation for school buses, then described the school buses. The school buses included alternate fuel. Everything was stricken to until we get to the phrase alternate fuel, and then everything after that was stricken, and then some prefatory language was stricken that was non-statutory. What's left would not be a complete and workable law under Justice Henry's test, or Justice Hansen's test rather in Henry, and certainly would be something that transformed the law in that an appropriation for school buses is not an appropriation for alternative fuel, much less electrical vehicle charging stations. The same can be said for the appropriation for grants for construction funds, where the legislature—
You have run out of time. I'm going to let you finish your answer to Justice Ziegler, okay? And I will probably give additional time then to Attorney Roth. But if you can do it succinctly, finish answering Justice Ziegler's question.
I will try to be as succinct as possibly can. The appropriation for construction funds, everything was stricken until we got to the word local grant. Obviously, what was stricken is not a complete and workable law, and the purpose of the law was transformed because an appropriation for road construction is not an appropriation for local grant, which is what was left. With respect to the vaping tax, what was a tax on basically e-cigarettes or vaping machines. I guess I don't really know the common parlance for that. Words were stricken in order to make this apply to associated projects. So the scope of the tax was expanded. What was excised is not a workable law. Finally, with respect to the fees on commercial trucks, what the legislature enacted was a uniform fee schedule, and the governor transformed it into a graded fee schedule.
Okay, thank you. Attorney Teslin, are you prepared to proceed?
Yes, thank you, Your Honor.
Please do.
Misha Tsaitlin for the Wisconsin Legislature. Article 5, Section 10 explains when the part that the governor approves shall become a law. It also explains when the part the governor rejects shall become a law. In light of this textual symmetry, the legislature respectfully submits that the issues being discussed by the parties in the court can be resolved in the following straightforward manner. Apply this court's longstanding complete and workable law test to both the part approved, as this court has done for 80 years, and the part rejected. The upshot of this textualist approach is that the legislature can only enact and the governor can only approve coherent policy changes, and then the governor can only reject, and the legislature can only override with a two-thirds veto coherent policy changes. This puts the political branches in this court's term in Henry onto a coextensive footing with regard to appropriation bills.
Counsel, how would you reply to the argument in the reply to your amicus that a small edit, say adding 3 additional words to a statute, how would that apply if that part is vetoed in regards to whether it becomes a complete and workable law when those 3 words would not be able to stand on their own? Or the same with any sort of modification of individual words in a sentence. How would that fit into your proposed test?
Right. So the way that the legislative bill drafting works in Wisconsin is you have an action phrase that says this subsection 3 shall be amended to read, or subsection 3 is changed as. So the way you would look at the complete and workable law text is you could use the action phrase and the edit. And when you use the action phrase and the edit, the complete and workable law is the change to the pre-existing law. So that's the way it works. That's the way the complete and workable law test works for the part approved. And that's exactly how it would apply for the part rejected. Now,
who comes up with the action phrase? I mean, who comes up with the action phrase? Your test is interesting if you read rejected separate and apart from sub B, but if you read the whole thing together, 2/3 of the members present can agree to approve the rejected part. They're not just approving 3 words struck or even 1 section struck. They're approving the entirety of what was struck. So who determines what the action phrase is?
Right. So what would happen under this regime is when the governor would send back the part rejected, he would no longer send back hand edits or item edits. He would send back the action phrase and the parts that he's rejecting. He would be sending back a complete and workable law. The legislature would look at the action phrase and the part rejected, and they say, do we want this coherent policy or not? And then they would vote with a 2/3 vote in the Assembly and the Senate to decide whether they were going to put this coherent policy into place. The coherent policy is the action phrase and then what happens with the action phrase. And that's the way it would operate. Now, Justice Hagedorn, I wanted to follow up a little bit on your colloquy with Attorney Essenberg. I do think that the veto in Henry is completely consistent with our test. In Henry, the governor was vetoing out the entirety of a newly created agency. Even though that was part of a single item, it was clearly a complete and workable law, the creation of a whole agency. So that shows, one, that what the governor was doing in the 1930s is consistent with our test. And two, that we are not, in fact, asking for an item veto. We are, in fact, asking for a complete and workable law test applied to both the part approved and the part rejected. And
are you asking us not to overturn Henry then? You would disagree with the petitioners in this case?
That's correct, Your Honor. Henry was correctly decided. There is some language in Henry that was then metastasized in the cases in the 1970s, just things that were plainly incorrect. But Henry struck out the creation of a new agency. That is, I think, pretty clearly a complete and workable law, even if it's part of a single item. Just that, whether something is part of a single item is often just a matter of legislative drafting. In Henry, the legislature appears to have put the creation of this new agency within a larger item, but I don't think that is either here nor there under the complete and workable law test.
So if we adopted your test, which cases that we've decided do you think we would need to overrule?
So I have 2 parts to that. First, with regard to the legal reasoning in the cases, I don't think necessarily any of the cases need to be overruled. All of the cases interpreted the phrase, the part approved. This court has never opined on the part rejected. And this, I think, is analogous to this court's decision in Denny, where this court had unanimously entered an interpretation of the DNA testing statute. And what happened was that this court had not looked at certain other language in subsection 12 of that statute. When that language was brought before this court adopted a different interpretation, and it certainly overruled the result that would have been reached in that prior case, but it didn't actually overrule the case in that it was interpreting new language. Now, with regard to result, this court would need to reach a conclusion that would lead to a different result in Kleschka and in Wisconsin State Senate versus Thompson. So those, I think, are clearly that if one applied the complete and workable law test to the part rejected, for those cases, you would have needed to reach a different result.
Counsel, using your test, the complete, entire, and workable law, both with respect to the language remaining and the language struck, would that still allow the governor to create new policy that had not previously been considered by the legislature?
Thank you, Your Honor. We tried to think of a hypothetical of how that could be, and we've really had a hard time doing it, especially when you combine it with the prohibition of combining two sentences that's in the constitutional text of Frankenstein veto. We were unable to come up with any hypotheticals where that could occur, although I think perhaps it is theoretically possible. But I would agree with Attorney Essenberg that even if there is a edge case where that is theoretically possible, the administrability of the long-standing 80-year-old complete and workable law test outweighs any harms that could be visited from the possibility that some governor somewhere will be more creative than myself and my team have been able to do and come up with something where you don't cross two sentences, both the part rejected and the part approved are complete and workable laws, and yet the fundamental aspect of the policies that the legislature was enacting somehow changes by the partial veto.
All right, so let's say that test works. I want to make sure I understand the objective that you're trying to obtain. Is it your position that the governor may not create a new policy through the exercise of his veto power that had not previously been considered and passed upon by the legislature?
That's right. That's the underlying rationale for a veto and a partial veto. And so that is what it gets at. But a lot of times both constitutional phrases and judicial doctrines reach those constitutional policy results through a more objective test, even if the ends being achieved are in some way subjective. And that is the way that we would look at it. But we do think that there are very important separation of powers principles here. And while clearly, as Justice Hagedorn pointed out, there is something legislative about a veto, it crosses a line that is, I think, requires far clearer constitutional text than this, to allow the governor to create brand new policies that the legislature never considered, and basically write them as a one-man legislature. I think that goes too far, and the court should be very weary of continuing any sort of doctrine that will allow that.
Suppose that's so, counsel, but how would you respond to the argument that every partial veto allows a change in policy from what the legislature has proposed? I mean, you know, every even small change, every dollar change affects a change from what the legislature was ultimately intending. And I understand there's the extreme examples in the way it has been applied by governors, but you know, I'm thinking about how you administer the point where we've gotten to the place where we change policy, seeing that evil. Every partial veto does that to some degree, doesn't it?
That's exactly right, Your Honor, which is why we would not ask you to accept the alternative approach that Attorney Essenberg put forward and accept the first approach, the Justin Hansen dissent from Kleshko approach, the one that comes from applying the objective complete and workable law test to both the part approved and the part rejected. That does not require any of those kind of inquiries, even though, as Justice Kelly suggested, it is grounded in some of the same concerns. The way it's actually operationalized would be an objective approach that wouldn't lead into some of those very difficult theoretical issues that you discuss.
Counsel, I believe in voices in the wilderness, but why should we adopt Justice Hansen's dissent? He was the sole dissenter, and in a long line of cases which were unanimous, they took a position contrary to him, as set forth in the Thompson discussion.
Counsel, I'm going to allow you to answer the question, but your time has expired. So I will be giving Attorney Roth the option of additional time on his argument, but please answer Justice Ann Walsh Bradley's question.
I'll be brief, Your Honor. We think that this court has never addressed the part of the constitutional text that the part rejected, and this court should address that text correctly, and none of the other justices who disagreed with Justice Hansen's test ever addressed that language either.
Thank you very much. Justice Bradley, do you think your question got answered, or did you want a follow-up?
Well, I would just point to the Thompson decision that took on that issue, and it said, again, the test in the veto of parts is simply whether what remains after the governor's veto is a complete and workable law. That's Thompson at 4:57. That's all I have to say. Thank you.
Okay, thank you. Attorney Roth, are you ready to proceed?
I am, Your Honor.
Okay, I'll give you, you have 40 minutes for your argument, but I give you the option of adding an additional 3 minutes. Do you want the timekeeper to do that, or are you happy with 40 minutes?
Yes, please. I'll take the extra 3 minutes.
Okay, so if you set him for 43, and you may proceed.
Good morning, Your Honors. May it please the court. Assistant Attorney General Colin Roth on behalf of the respondents. Before getting into the weeds, I think it's important to take a step back and recognize that the Wisconsin people have spoken on the governor's veto power, not just once, but 3 separate times. They first spoke in 1930 through an amendment that gave the governor a partial veto rather than an item veto. And they spoke again in 1990 and 2008 through 2 amendments that ratified the unbroken line of cases from this court that again confirm that Wisconsin has a partial veto, not an item veto.
Attorney Roth, how do you respond to Mr. Essenberg's statement that he made that the people may have spoken, but they only spoke in limited ways with what was presented to them?
I think it's very difficult, if not impossible, to read those 2 amendments as anything but approval of this court's decisions from Henry leading up to Thompson, except for the one specific veto practice that the 1990 amendment disapproved, which was the veto of individual letters. And the reason I think you simply have to reach that conclusion is that, and I think the petitioners even concede this, the 1990 and 2008 amendments both used the word part in the exact same way that Henry understood the word. And I think one of the most basic principles of constitutional interpretation is when we examine the text of the Constitution, we have to give the same word, the same reading throughout the Constitution. And I think if we concede that in 1990 and in 2008, the Wisconsin people saw an amendment that essentially said the governor can veto any part of an appropriation bill against the backdrop of this court's case law. We have to assume they understood what that meant. But the only change we want to make to this court's doctrine is to remove, first, the ability to delete individual letters, and second, the ability to combine sentences. I think those are 2.
Counsel, when did the people of Wisconsin give power to the governor to create law that was never considered or approved by the legislature?
I think that decision was made in 1930 and then again in 1990 and 2008 when the Wisconsin people chose to give the governor a partial veto. I think we begin with the text the people chose, determine what that text means, and we follow where it leads us. And I think
veto means disapproval or rejection. Where does veto, where in the Constitution or anywhere else is veto defined to include the power to create?
Well, I think if you look at the constitutional text, it actually does not use the word veto except in the title of Section 10 to determine what kind of power the Wisconsin people intended to give the governor. I think we need to look at the actual text of subsection B, and especially in context with subsection C. And again, subsection B reads, appropriation bills may be approved in whole or in part. And I think we have to understand what the word part meant. And that's what this court has always done from Henry through Kletchka and Thompson. It's looked at the word part. It's compared it to item vetoes that were available to the people that they could have chosen. Instead, they chose a partial veto. And I think when they made that choice, they necessarily granted the governor a degree of legislative power. I mean, I think it's absolutely true, as Justice Hagedorn recognized, that even a traditional up or down veto, the presentment clause that was originally included in the Wisconsin Constitution, involves the governor in the legislative process. And so what happened in 1930, I think.
Counsel,
go ahead.
Yeah, I'd like to do a little bit of a stress test on that. I want to take you back to something that you wrote at page 17 of your brief, in which you said, in both cases, and you're referring to the 1990 and 2008 constitutional amendments, in both cases, the people recognized that the Constitution's existing language did not impose these restrictions, the ones in the constitutional amendments, and so new express language was needed to do so. Is it your position, and if I refer to the Vanna White and Frankenstein vetoes, you'll know what I'm talking about, right?
Yes, Your Honor.
Okay. So is it your position that the 1930 amendment creating the partial veto, that allowed for the Vanna White and Frankenstein vetoes?
I think it did. I think Thompson was correct.
All right. So now in Henry's analysis of the extent of the veto power was based on, as you say, the distinction between the word part and the word item. Is that right?
That's correct.
Okay. So in comparing part to item, Henry came to the conclusion that it did. What I'm curious about is, did Henry ever compare the word part to Article 4, Section 1, the vesting clause for the legislature?
Henry did not discuss Article 4, Section 1.
Okay. Did it compare the word part to Article 4, Section 17, Sub 2, with respect to the requirement that no law shall be enacted except by bill?
It did not, but those provisions were considered in later decisions by this court that visited the meaning of the word part. And I think—
hang on just a second. So did in Henry, because Henry's the root of all this, correct?
I think the 1930 amendment is the root of all this. It's the text of the Constitution.
Yes, that's the constitutional text that we're considering. But the first case to decide what the broad parameters of the partial veto were, that was Henry, correct?
Henry was the first case to interpret the text. I will say that Henry could only analyze the partial veto that was before it at the time, and so it may not have needed to. It
could look at Article 4 to decide what the proper extent of this brand new constitutional amendment was, correct?
It could have, and later cases did.
Okay, hang on. So I just want to make sure I'm correct on the cases here. So in coming to this conclusion, did the Henry court compare the word part to Article 4, Section 19, requiring that a bill originate in one of the houses of the legislature?
It did not, but I really don't think that's determinative of the question we're here to answer.
That's kind of my question then. Why is it that we have come to a conclusion that the governor may propose legislation that the legislature never considered, and that it can only be disapproved by a supermajority of both houses of the legislature? How is it that we've come to that conclusion while never once in all of our cases analyzing the effect of the word part on Article 4, Section 1, Article 4, Section 17, Sub 2, and Article 4, Section 19? How is it that we can have a coherent constitutional jurisprudence when we've never compared that word to those requirements?
Your Honor, I don't think that's accurate. I think if you look at Justice Heffernan's decision in Kletschka, and specifically footnote 3 of his decision, Justice Heffernan analyzes this issue in great detail, starting from first principles about the meaning of the separation of powers doctrine and how it is defined by the constitutional text and not by abstract doctrine. And I think what Justice Heffernan recognized is that, yes, the vesting clause does vest the legislative power in the legislature. But I would just note that there are many, many examples in our state constitution where, despite the vesting clauses, which on their face may appear to be exclusive, nevertheless, pieces of that power are expressly given to other branches of state government. So I think that's point one. These vesting clauses are not exclusive, and Justice Heffernan recognized that. I think the second point is that we are a system of shared powers. I think the nature of checks and balances, where each branch has the opportunity to check the other, is a fundamental piece of our government. And again, that's another core principle that Justice Heffernan and Kletschka recognized. And so based on those two core principles, I think this goes to Justice Hagedorn's point that by creating a partial veto rather than an item veto, the Wisconsin people expressed their intent to grant a quantum of legislative authority to the governor strictly in the budget context. And I think another core data point here to remember that we haven't yet discussed is the very same legislature that passed this 1930 amendment for a second time also enacted the modern executive budget process, whereby the governor has the first shot at drafting the budget bill. He drafts the budget bill and sends it to the legislature. Of course, the legislature then gets its shot. But I think it's yet another data point that indicates when the people passed this amendment in 1930, this was part of a shift that did involve the governor in the legislative process more clearly. And so once I think we establish those core principles, then we must look at the text itself to determine how far they take us.
Okay, hang on a second. So here's my bottom line concern. Maybe you can bring something to the debate that will satisfy me on this. This is a significant transformation of legislative authority and moving it to the governor's office. And it seems that we've done that with reliance on an interpretation of a single word, parts, right? That's the whole ball of wax here, is how do we define parts? And we've defined that so that the governor has a power to propose policy the legislature never considered, and it becomes law unless both houses by a supermajority veto his policy proposal. And we do that based on this one word, part. So could you help me out, show me any textual clue, any contextual clue, any debate from 1930, anything at all to suggest that the legislature and the people of Wisconsin understood that the word parts would involve this radical shift of legislative power to the governor. Is there anything you can point me to?
I think I've already discussed how in 1930 there was a movement to give the governor great authority in this budget process, both through his statutory role to draft the budget bill and by expanding his pre-existing presentment clause up and down veto power into something more, a partial veto power. I think those are both clues.
Hang on just a second there. So in Henry, we talked a little bit about that, right? And we said that the governor's partial veto power needed to be coextensive with the legislature's power to bundle. So when we talked about this in Henry, we were talking about the partial veto power being the power to unbundle what the legislature had bundled, right?
In Henry, that was the veto before the court, so that was the focus of its discussion, yes.
So is there anything else up to the time that we decided Henry? Was there anything else extant in the record anywhere, the public record, the legislative record, the debates, the text, the context, anything that would suggest that the word part would do anything other than unbundle what the legislature had bundled?
If you're asking me whether there's a statement by a legislator describing how the word part would ultimately be implemented, no, there's not. But I think there's a clear difference between part and item. I think that is undisputable practically, given the dictionary differences, the use of the word item in other states, the 1925 amendment. Hang on a second.
I'm not terribly interested in the word item. It does not appear in the Constitution. What I'm interested in is how this word part interacts with other parts of the Constitution. And what I'm looking for is any text, context, or public debate that would inform us that the original public meaning of the word parts was that the governor would have the power to propose law and have it become law unless some supermajority of both houses vetoed his proposal. Is there anything contemporaneous that would suggest that?
I guess I'm not aware of an extrinsic source of commentary that said that. But I just don't think that's determinative of this case, because the people chose a specific word. And what this court has always recognized is that we begin with the text and we follow where it leads us. And I think the second thing I'll say.
We also say that we look at the word in context. Yes?
That's correct.
Okay, the context is the entire Constitution. And the context is the vesting clause, the origination clause, the amendment clause. That's the context we have to look at this in. So what do we look for when we're looking at the word parts? What should we be looking for in that context to tell us that this was a transfer of legislative authority to the governor of this magnitude that would allow for the Vanna White veto and the Frankenstein veto?
Well, I think we look at the dual purposes that this court has recognized for the partial veto. One is to give the governor greater control over the budget bill that he himself drafts and introduces in the legislature. And two is to unbundle omnibus appropriation bills. If that's not convincing to your honor, I would submit that the Wisconsin people understood this debate in 1990 and 2008 after Thompson. I must emphasize that the 1990 amendment was proposed 16 days after this court issued its Thompson decision, in which it said that a partial veto.
Yeah, so maybe what the people of Wisconsin were responding to is not the constitutional text, but our opinion.
Well, see, I fundamentally disagree with that, because I think if petitioners' view of those amendments was correct, and what they really signaled was a fundamental disagreement with what this court said in Henry, those amendments would have looked nothing like they did. They would have instead looked like one of the menu of amendments that the legislature has rejected over the decades that would have actually created an item veto, a section veto, a reverse complete and workable law test. All of those have been considered by the legislature over the years. And so if that's what the people intended after Thompson, they would have approved that kind of amendment. But that is not what they approved. Instead, understanding the Thompson decision and where this court had led us, the people essentially said, we are ratifying Henry. We are ratifying the court's decisions that followed from Henry. We are even ratifying Thompson, except for two specific practices that Thompson blessed, the letter veto and the combined sentence veto. And so I agree with, Your Honor may doubt what the people intended in 1930. I may not be able to persuade you to eliminate that doubt, but I don't think we're writing on a blank slate here. I think it is critical that we give effect to the 1990 and 2008 amendments. And let me try it a different way. I think what petitioners are ultimately asking this court to do is privilege the 1930 amendment over the 1990 and 2008 amendments. And I'm simply not aware of any principle of constitutional interpretation that allows this court to essentially pick and choose which pieces of the Constitution it wants to privilege over others. I think each of subsection B and C in Article 5, Section 10 must be respected and must be given effect. And so I think the bottom line is the people spoke in 1990 and 2008 against the backdrop of this court's decisions. Of course, it's against the backdrop of this court's decisions. I won't dispute that. But I think what they said was, we think that this distribution of power is the one we want. Are there other distributions of power that we could choose? Of course there are. Of course we could restrict the governor's veto power more. But instead what we're going to do is stick with what this court has always said and only remove what we think are the two most aggressive uses of that power. And so I think we simply can't turn back the clock now at this point and ignore those expressions of the people's will. I just am not aware of any constitutional interpretive principle that allows us to do this. And I really do think it's not simply a matter of rendering those amendments superfluous in the sense that, if we revisit 1930 and we get it right this time around, well, that's no problem. because that's what the people really intended. It's not even as much about rendering those amendments superfluous, is understanding that those were really ratifications of what this court has said over the near century of its consistent decisions.
Counsel, let me just follow up on that with a hypothetical for you, or maybe it's not that hypothetical. Women were granted the vote via constitutional amendment, correct? So do you think that ratified an interpretation of the 14th Amendment that ensures that women have no political rights under the 14th Amendment?
Well, I don't see that as comparable here, because there's nothing left to infer about. If the issue is, do women have the right to vote? Clearly the amendment said yes, and there's nothing left to infer about the 14th.
The inference would be the 14th Amendment says nothing about the right of women to vote.
Again, I'm not sure that once the amendment was passed, the subsequent amendment, there's a need to infer anything about the 14th Amendment. I mean, it does, but I don't see those as comparable.
Just by way of analogy and thinking through this, and I see the textual argument you're making, and there's a lot of strength to it, but the counter argument, of course, is, and just to get more abstract for just a minute, suppose you have an amendment that says X. The court interprets it to mean X, Y, and Z, and the people muster the political will to take out the Z. Does that mean that the amendment now means, as a matter of original public meaning, X and Y?
I think it does here, because by using the word part in the way that the legislature did, and again, this is an amendment crafted by the legislature, drafted by the legislature, and passed by 2 consecutive legislatures, and then ratified, by using the word part, and again, petitioners concede this, I think the legislature does also, that necessarily meant X and Y are still allowed. I think if we intended to disallow X, Y, and Z, again, like I said earlier, I think the amendments would have looked far different. They would have looked like, X, Y, and Z are not allowed. But I think, again, the basic principle is by saying in vetoing, in approving a bill in part, the governor may not reject individual letters to create new words. I mean, purely as a matter of grammar, that's incoherent if the word part means what the petitioners and the legislature say it does. And I don't think we should lightly ascribe incoherence to the people when they're ratifying constitutional amendments.
It wouldn't have been incoherent in light of this court's interpretations and decisions, would it?
Sorry, I guess I don't understand. Maybe I'm missing the question. I mean, I think, imagine in those amendments, the word part meant what the petitioners and the legislature say it does. So in the place of part, read in those amendments, in approving an appropriation bill in part, and by part we mean only a part in which the rejected part cannot be a complete and workable law, the governor may not create a new word. I mean, those 2 clauses would not fit together. They would just make no sense.
My question was directed at, I think, something that was brought up earlier, perhaps by a different attorney during this argument. But the point is that perhaps the amendments responded to interpretations by this court of the constitutional text rather than the original meaning that the petitioners would ascribe to it. So in that sense, it wouldn't be incoherent.
Well, I still think, I will not dispute that it responded to this court's decisions. I think that's, of course, what it did. The 1990 amendment in particular responded to Thompson. But in responding to Thompson, it baked into that amendment is the very decisions that this court has always made. And I guess my incoherence point is I don't want to overstate it, but I mean, I think it's really a grammatical one. When I want to understand the text and when I want to understand what part means, I can't ascribe to the word part a definition that would result in an incoherent sentence that simply does not fit together. And I think the only interpretation before this court today of the word part that gives a unified meaning to each usage of the word throughout the constitutional text is the one that this court has always adopted. It's the one that the people approved in ratifying the 1990 and 2008 amendments. It is simply not the ones presented by the legislature and the petitioners.
So in acknowledging that this court's decisions are baked in, I think is the expression you used, are baked into those amendments, what if this court is to determine that prior courts got it wrong?
Your Honor, I don't think that, frankly, I do not think it's any longer within the court's authority to do so. And the reason is because when the people spoke and baked in an assumption that this court got it right, that is a ratification of those prior decisions. And I really don't see any source of authority to ignore those expressions of the people's will. I mean, I think we have to remember that this is an amendment.
How can it be a ratification of this court's decisions if the amendments were responding to the court's decisions, which I think you would probably also acknowledge the people do not have the prerogative to disregard, nor does the legislature, nor does the governor, right?
Well, I think both the legislature and the people have the power to change the Constitution. And so in that sense, of course, everyone has to follow the decisions that the Supreme Court makes if they're constitutional decisions, but the people can change the Constitution through their amendment authority. That's what Article 12 says. And so in responding to those decisions, if the people thought this court got it wrong, they could have themselves crafted an amendment that expressly said so and said, you know, we want to transform this partial veto power into something entirely different. We want to turn it into an item veto or a reverse complete and workable law veto. You know, there's a whole menu of things that the people could have chosen. But rather than make one of those alternative choices, they selected a very modest one, which is we are going to incorporate everything this court has done and just bar two specific techniques that follow from it. So I just don't think, now that the 1990 and 2008 amendments have been passed, there's no going back. I think the only way to select a new partial veto power is to go through the deliberative Article 12 amendment process. And I'd like to take a minute to talk about why I think that's so important here. I don't think that either alternative that the petitioners have offered is going to be some panacea for either separation of powers concerns or day-to-day governance. I think there are serious problems with both. Yes?
Before you go further down a different path, I just need to clarify something in my mind. We generally think of the legislature being vested with the power of the purse, the ability to legislate. I understood your argument to be that here vesting is not exclusive, it's a shared power because it involves spending in the budget context, right?
I wouldn't put it precisely that way. I would say, as a default matter, yes, the legislative power is vested in the legislature. That is certainly the default principle that applies. However, I think the constitutional text in this circumstance expressly assigns some of that power in the appropriation context to the governor. So I think in this context, the text itself creates the shared power. That's why the default principle does not apply here.
So in this context, the legislature is not endowed with the authority or power of the purse. It's shared.
Well, yes, and yes, it shares that power with the governor. I mean, I think, again, we see that through the governor's ability. And again, this is contemporaneous with the 1930 amendment, statutes granting the governor the power to draft budget bills.
What, if any, limits are there, since a lot of things involve spending money? what limits are there then on the governor legislating?
Well, the constitutional text provide the limits, I think, is the answer to Your Honor's question. It's a power only in the context of being presented with a budget bill from the legislature. Obviously, the governor cannot pass a bill on his own. He needs to receive a bill that the legislature has sent to him. But once he receives that bill, then he gets to use the tools that the Constitution has given him to make the changes based on that power. And I think it's critical to emphasize that that's not the end of the process. The legislature has tools to defend its prerogatives here. Again, this is a shared power. It's checks and balances between the two branches. And so I think the legislature can override the veto. It can keep policy provisions out of its appropriation bills entirely, such that they're not subject to the governor's veto pen at all. Again, it's critical to remember that this partial veto power extends only to appropriation bills and not to pieces of general legislation. So,
does it
or the legislature, just to finish, or the legislature can propose another constitutional amendment to change the governor's veto power. So again, I just want to emphasize the legislature is certainly has obviously a primary and defendable role in this process.
So in any appropriation bill, the governor can legislate?
Well, I think he can approve the appropriation bill in whole or in part. And how you characterize the result of his approval in part, whether you call it an affirmative power, a creative power, I mean, I think those are just labels that we're assigning to the end product of what the constitutional text allows the governor to do. I don't know that it really is that analytically helpful to say, well, this is an exercise of legislative power or affirmative, creative power. I really don't know that those have much explanatory power here, given that I think we start with the text and follow where it leads. And again, recognize that there are two express limitations that the people have chosen to place on the power, and that's it. So I think those are the limitations, if that answers Your Honor's question.
Okay, thank you.
I would like to follow up on an earlier question asked by Justice Ziegler at the start of this hearing. And she asked about what are the arguments being advanced regarding the infirmities of the 4 partial vetoes here. You've got the school bus, the construction fund, the vaping tax, and the fees on the truck. And there were 2 responses. You have to change the test under existing law. I take it from a petitioner, and petitioner can correct me if I'm wrong when he's back up to bat, so to speak, that there is an acknowledgement that under existing case law, these vetoes are lawful. But they ask for 2 things. Number 1, a change so that what is left is part of the test, and what is left has to be complete and workable, not just what's passed. And the second thing is that the veto cannot transform policy. That's another way of talking about legislation or prescription rather than proscription, as discussed in some cases. So what's your response to why these 4 vetoes are lawful, and zeroing in on should we be changing the test to what's left is also not complete and workable, and transforming policy is verboten?
Sure. I think to answer Your Honor's question, I don't think any of us dispute that under this court's current case law, and by us I'm referring to the petitioners in the legislature, that under this court's current case law, each of the 4 vetoes here is lawful. I think everyone agrees with that. And so, again, the only way we can overturn any of these 4 vetoes is through a decision that I think overrules practically every one of the decisions this court has ever issued and essentially deletes 2 constitutional amendments. And so that's the only way we get to a invalidation of these 4 partial vetoes. Now, I'd like to maybe use the 4 vetoes here to expand on I think one of the last points I wanted to get to, which is if we actually look at the 2 tests that are proposed here, and again, I strongly disagree with the premise that we're at liberty to simply select from a menu of options. I think the people have already made that choice. But in any event, both tests that are proposed here, it's not at all clear to me that these are going to be administrable tests. I think especially this idea that we can examine legislative intent to determine whether the legislature would have passed the bill without the vetoed part. I think that's just an absolute nightmare for this court to get involved in. Consider Governor Walker, 309 partial vetoes during his time in office. Is the judiciary really going to start examining each of those 309 partial vetoes and trying to understand if the legislature would have intended to pass them anyway without the vetoed portions? I think I cannot even imagine how that would work. It would be, frankly, chaos in the budget process. The governor could not predict which vetoes would stand. The legislature would have no idea either, I don't think. And regulated parties, importantly. I mean, people depend on stability in the budget once it's passed. But I think this test is going to create massive uncertainty, tie up significant portions of the budget bill in litigation every 2 years. I mean, with this new test, if that's adopted, I mean, this court will be called upon again and again and again to resolve how it's applied to individual cases. I suppose the test would be settled, but someone has to apply it to the individual vetoes. And I just don't see how that's workable in any way. And I think that people wisely chose a different system. I mean, that's why the Article 12 amendment process is so critical when considering such a structural issue as this one. I think it's so important that 2 legislatures and the Wisconsin people have the opportunity to consider this kind of sweeping revision that the petitioners are asking for. Consider the strengths and weaknesses, the drawbacks, the trade-offs, all of those, and only then approve such a transformational change. And then I guess what I'd say for the reverse, so again, I mean, we can look at any of the 4 vetoes here. I have no idea how to evaluate whether the legislature would have passed them anyway. I mean, it's a mystery to me. And in terms of the reverse complete and workable law test, I'm not convinced that would be much more clear than this inquiry into legislative intent. I don't know how it would apply to appropriation amounts. I don't think anyone disputes that writing down appropriations or zeroing them out is in the core of what the governor should be able to accomplish through the partial veto. I don't know, are those vetoes going to survive? I don't think Xing out $1 million appropriation is a complete and workable law. So I think that's out the door. And again, and ultimately what it would accomplish is the legislature would learn the new test, and what it could do is essentially daisy chain the whole budget together and say each part is contingent on every other part. And so none of them can be excised without the entire bill falling. And I think that's that would undermine the fundamental purpose of the partial veto, which is to allow the governor to pass on individual pieces within an omnibus budget bill. So I think there are real disadvantages to either of the tests the petitioners have proposed here. And again, I will say that when the people spoke in 1930, 1990, and 2008, they made their choice. I think they had a menu of options in front of them. The legislature has had a menu of options in front of it. And they didn't choose a reverse complete and workable law test. They didn't choose a test focused on legislative intent, that would be extremely difficult to administer. They chose the test that we have now, which has the virtues of being clear, predictable, and provides both branches with an adequate opportunity to defend its prerogatives. And so, I mean, look at these 4 vetoes. We can examine them, any way we want. But I think the bottom line is that they're undoubtedly lawful under this court's current case law. They're undoubtedly lawful under the 2 amendments that the people ratified. And the only way to invalidate them is to essentially start from scratch and build a whole new partial veto doctrine from the ground up. And I think it's simply too late in the day for this court to do that, given the 1990 and 2008 amendments. That was the expression of the will of the people, and it must be respected. I don't have much more to say unless there are further questions. I'm happy to answer. I guess I could say one part about just add to respond to the legislature's textual argument. I think it rests on a fundamental misunderstanding of what the phrase "shall become law" means throughout Article 5, Section 10. Again, all that means is when a bill is approved by the governor, it acquires the force of law. And it's a mistake to think that the part rejected somehow needs to be a complete and workable law. I think that's a complete misunderstanding of how the test originated. A rejected part simply never becomes law unless it's overridden by the legislature. And so there's no need for a part rejected to stand alone. I think the reading that this court has always given to the word part, again, is uniform throughout Article 5, Section 10, and that's what constitutional interpretation requires. So with that, if there are no other questions.
Thank you. Attorney Essenberg, are you prepared for rebuttal?
I am. Thank you, Your Honor.
Please begin.
I'd like to return to Justice Hagedorn's example of the 14th Amendment. There are certainly canons of construction that we could use to argue that once the people passed a constitutional amendment giving women the right to vote, they were making a judgment that the 14th Amendment did not apply to distinctions based on gender, as courts at the time probably thought it did not. But it would be implausible to make that conclusion or then to subsequently argue that the 14th Amendment can't possibly apply to gender because it would render the amendment granting women the right to vote superfluous. That's simply, that might be an argument that we might make with respect to legislative determinations, but it's simply a fiction when it applies to the passage of the people by constitutional amendments. All of this rather odd situation that we have here, where the governor and the legislature play this game to determine what becomes the law of the state of Wisconsin, rides on a definition of the word part. But as we pointed out in our brief, contemporary dictionary definitions of the word part do not compel, in fact, do not even strongly support that construction of the word part. It is one definition, piece or fragment, but are also definitions that indicate that a part is a coherent and an identifiable subdivision of the whole. And so now we look at the context of the use of the word part, and we find that it is used in conjunction with approval or disapproval. And reassembling and recreating a law is not, in common parlance, approval or disapproval. If we look at the purpose of Article 5, Section 10, we find that the purpose was to respond to the legislature's practice of combining multiple separate legislative initiatives in an omnibus budget bill. This suggests to us that the part that the governor ought to be able to veto are any one of these legislative initiatives that have been combined into an omnibus budget bill. There is nothing in the history of this amendment, absolutely nothing, that would indicate that the people of the state of Wisconsin contemplated enacting a constitutional structure in which the governor and the legislature would play this game that they play every year, every 2 years rather. And so it's, I think, relatively easy to conclude that the decision was unsound, that this rule that permits this to happen is unsound in principle, and certainly wasn't ratified by the people in 1990 and 2008, because once again, there's nothing in the history surrounding those amendments which suggests that they were passing upon this general principle or concluding that we think that the governor can rewrite laws as long as he stays within a single sentence. Mr. Roth suggests that, well, if the people really wanted to change this, they would have passed a different amendment. But just as when the people passed upon an amendment that only gave women the right to vote, the people of the state of Wisconsin in 1990 and 2008 were passing only upon an amendment that was directed to particular abuses. They were not asked any other question, and so their answer to that question cannot be inferred or assumed. I don't think that we can place much weight on legislative acquiescence or the fact that the legislature hasn't set forth a different amendment because of the important separation of power principles involved here. The separation of powers, as this court has recently recognized, is not for the benefit of those who hold the power to protect the people. And so when it comes to enforcing our separation of powers, waiver by the political branches is not an option. And just as the Supreme Court, U.S. Supreme Court did in INS versus Chadha, where they struck down the legislative veto, even though it had been utilized approximately 300 times in our history, that it is the duty and the role of this court to say what the law is.
Counsel, let's assume you prevail with regard to the new test, that which has been rejected has to also be complete and workable. What's the remedy is my question. In reading the legislature's brief, it indicates on page 12 that the remedy should not include disturbing the vetoes in this case, but rather be prospective only. What's your opinion or argument with regard to remedy? Are you in accord with the legislature's suggestion, or do you disagree with it?
Well,
Counsel, your time is again, it's disappeared on you, but please answer Just Ann Walsh Bradley's question.
I will, thank you. Under the law as it exists, because the vetoes would be ineffective and the law originally enacted would become law. We indicated in our brief that because we acknowledge that we're asking for a change, that the court might indicate that these particular vetoes can be sent back to the governor and he can either approve them or exercise a proper veto. Because we are challenging these provisions as an unlawful expenditure of state funds, we do not ask that that there be some type of sunburst treatment of them and any new rule that's adopted be prospective only. We understand, however, that is within the court's prerogative and that the court may choose to do that.
So the answer is you disagree with their proffered remedy.
Yeah, we asked for something different.
Okay, thank you all. And attorneys, thank you very much. I think this worked fairly well, at least from our perspective on this side of the bench, and I hope you found it satisfying as well. I know the next case that we have has similar issues, but the court is going to take a 10-minute break, and then we will be back with you for the second case of the morning. So we are adjourned.
This program is a production of WisconsinEye, an independent, nonpartisan, nonprofit media network with a mission to inform, educate, and engage the citizens of Wisconsin. WisconsinEye is the nation's first and only independently funded state civic broadcast network, providing gavel-to-gavel access to government proceedings and events at the state capitol.
Hi, I'm John Henkes, president of WisconsinEye Public Affairs Network, and I'm speaking to you today to ask for your financial support. For 14 years, WisconsinEye has provided uninterrupted, gavel-to-gavel live coverage from our state capitol, the legislature, the Supreme Court, the governor's office. We're proud to continue to do that and continue through this time of crisis with important coverage. We are 100% committed to bringing these important meetings into your home or place of work. We've created online pathways that allow us to connect you live with these important events. But WisconsinEye needs your help to do so. At this time, we are facing unprecedented staffing, technical, and financial challenge. So if you rely on our coverage to stay informed on issues you care and need to know about, I ask that you consider a one-time charitable gift today to help us through this challenge. Whether you're following the DHS briefings, the Wisconsin Elections Commission, or leadership briefings from the state capitol, or any of the timely interviews conducted by our senior producer, Steve Walters, we could use your support today. If just a fraction of the thousands who value WisconsinEye coverage say yes with a gift of any size, it will provide a huge boost. So thank you. To donate, please text WisEye to 44321. That's WISEYE to 44321, or visit wiseye.org/donate, WISEYE.org/donate. Or you could send a check to 122 West Washington Avenue, Suite 200, Madison, Wisconsin, 53703. Again, thank you so much. Please be safe. Stay optimistic. We are Wisconsin.